And with the first bill is our policy bill, really huge bill here before us. Chair Schumacher, will you please move your bill and proceed?
Thank you, Mr. Chair. I would move that House File 2115 be re-referred to the General Register.
All right, please walk us through the bill.
Thank you, Mr. Chair. I would like to move, we have a couple of amendments. First, the DE2 amendment.
We have D2 amendment before us. Members, if you haven't had a chance to review the D2, we'll get the walkthrough. So this is to put the bill in the shape the author wants. All those in favor, please say aye.
Aye.
Opposed, say nay. The amendment is now adopted. To the bill as amended, DE.
And thank you, Mr. Chair. I would like to also move the A2 amendment to the DE2 to further get the bill into the form that I would like it discussed. This one, just the first part is a rewrite of one piece of the DE2 to clean that up. The second portion is the bill that we had up yesterday and was presented so well that we decided to adopt it into today's bill. And then the final piece with all the effective date changes deals with direct care and treatment to make sure that the policy goes into effect when the department goes into effect.
All those in favor of A2 amendment, please say, to DE2, please say aye.
Aye.
Opposed? The A2 amendment to DE2 is now adopted. To your bill as amended, Mr. Chair.
Thank you, Mr. Chair and members. This bill is a culmination of the work of this committee throughout the year. We did on a very bipartisan basis go through the language that was in the bills that were heard and pulled out the pieces that did not have costs. I think we have one up on the Senate on that piece of it, from what I understand. And the things that we were able to agree to, we put into this bill so that we can continue to get a lot of good things done. For the details on that, I would like to have House Research do a walkthrough for us, please.
Ms. Bonanno.
Mr. Chair and members, starting with Article 1, that article relates to aging and disability services. Section 1 is from Representative Knorr's House File 2722. It modifies positive support analyst qualifications. Sections 2, 3, and 5 through 8 are from the Department of Human Services policy bill relating to aging and disability services policy provisions. Sections 4 and 14 are from Representative Hansen's House File 257. It establishes a review process upon notice of agency denial, reduction, suspension, or termination of long-term services and supports. Section 9 is from House File 671, Section 15. It's a Representative Hicks bill. It modifies services parents are allowed to provide under the CDCS option. Sections 10 and 11 are from House File 2331. It's Representative Knorr's bill exempting assisted living providers from direct care staff compensation requirements under DWRS. And sections 12 and 13 of Article 1 are from House File 2159, Representative Schumacher's bill that corrects terminology in the chapter of statutes governing nursing facility payment rates. If there aren't any questions on Article 1, we can move to Article 2. This article relates to Department of Health policy. Most of this article is from various Department of Health policy bills, sections 1 through 4, 6 through 15, 19, and 21 to 23 are related to case mix classification modifications for federal conformity, supplemental nursing services agency updates, assisted living facility updates, and medication training program approvals. Sections 5 and 20 of Article 2 are from House File 2407, Representative Zalesnikar's bill that provides residents of long-term care facilities with the right to a designated support person. And sections 16 to 18 of Article 2 are from Representative Muller's bill, House File 2216, which prohibits termination or non-renewal of assisted living contracts on certain grounds.
Ms. Sandeman.
Mr. Chair and members, moving to Article 3, which is starting on page 29 of the DE. Most of this article is from the DHS Policy Bill, House File 2115 as amended. Sections 1 through 7, 13 through 25, 27 through 30, 34, 37 through 40, 42 to 44, 48, and 56 to 90. All of these sections update statutes to account for the new Direct Care and Treatment Agency. These sections add Direct Care and Treatment and the Direct Care and Treatment Executive Board or Chief Executive Officer where necessary in statutes, and makes additional technical changes related to the new agency. Sections 8 through 12, also from the DHS Policy Bill, modified the definition of residential program in the Patient's Bill of Rights in Chapter 144 to include additional facilities and programs serving children, and these sections also make technical changes. Section 26, also from the DHS Policy Bill, outlines requirements for unmarked vehicles used by the Direct Care and Treatment Office of Special Investigation staff and used by the Minnesota Sex Offender Program's Executive Director and their staff. Section 31, also from the DHS Policy Bill, updates and clarifies state-operated services, crisis services, technical assistance language. Section 32 from the DHS Policy Bill exempts the Direct Care and Treatment Executive Board from the 18-month time limit on rulemaking. Section 33 requires the DCT Executive Board to establish standard admission and continued stay criteria for state-operated services facilities. Section 35, also from the DHS Policy Bill, allows for reimbursement for travel expenses to and from interviews arranged by DCT for certain recruited positions. Section 36 from the DHS Policy Bill authorizes the Executive Board to contract with specified federal agencies to receive federal grants related to the welfare and relief of Minnesota Indians. Moving to Section 41, this is the extension of the 48-hour rule change from 2 years ago, that extending it for 2 years until June 30th, 2027. So it extends the provision that specifies that individuals who meet the criteria for priority admissions to be admitted to a state-operated treatment program within 48 hours of when a medically appropriate bed is available. And the last batch of sections, these were from House File 2187, which was the clone as amended of the Direct Care and Treatment article of the DHS Policy Bill, authored by Representative Frederick. These sections remove the requirement for the Special Review Board hearings, review, and recommendations when committed individuals in the Minnesota Sex Offender Program petition for a reduction in custody, and replaces this with the Judicial Appeal Panel hearing and review, and makes conforming technical changes. And that concludes the walkthrough for Article 3. Moving to Article 4, this is on page 111. This is the behavioral health article. Section 1 from House File 98 as amended by Representatives Fisher and Gilman. This exempts intensive residential treatment services, or IRTs, and residential crisis stabilization residents from certain rights in the Healthcare Bill of Rights. Section 2 from House File 1995, the first engrossment, from Representative Frederick, prohibits courts from ordering persons convicted of DWI or DUI to pay costs of SUD treatment covered under medical assistance or the Behavioral Health Fund, or SUD assessments covered under those funds. Section 3 is also from House File 98. This section modifies adult mental health case management service provider training and qualifications. Section 4 from House File 2143 as amended from Representative Momanya Hiltsley modifies the definition of mental illness. It updates and adds post-traumatic stress disorder to serious and persistent mental illness for purposes of case management and community support services. Also from House File 2143, Sections 5, 7 through 10, and 35 add complex post-traumatic stress disorder to case management and community support services throughout the Adult Mental Health Act. Section 6 is from House File 973 as amended from Representative Backer. This prohibits county boards from charging for emergency services provided to clients experiencing emotional crisis or mental illness and requires promotion of the 988 Lifeline. Section 11, which is from two different bills, is from House File 2115, the DHS policy bill, and from House File 98. These are modifications to the Children's Mental Health Case Management Service Provider Training and Requirements. Section 12 is from House File 671 as amended from Representative Hicks. These are changes in the Children's Mental Health Act to expand the definition of child to include individuals up to age 21 who are receiving children's mental health targeted case management services. Section 13 is from the DHS policy bill. This defines clinical supervision in the Children's Mental Health Act. Sections 14 and 15 are from House File 2196 as amended from Representative Fisher. This is the big children's mental health terminology bill, but these sections had some slightly more substantive changes, so they are in behavioral health. They add treatment service coordination requirements, and they modify the county board screening duties. Section 16 from the DHS policy bill adds a written functional assessment to the duties of a children's mental health case manager. Section 17 from House File 669 from Representative Hicks. This adds to school-linked behavioral health grant allowable grant activities, accessing caregiver mental health services. Section 18 is from the DHS policy bill. This section codifies the Intermediate School District Behavioral Health Grant Program. Section 19 from House File 671 as amended. This modifies mental health certified peer family specialist grant activities to include continuing education. Section 20 is new language that allows a certified community behavioral health clinic to enroll as a provider of mental health crisis response services without a county contract or county approval. Section 21 is from House File 1993 as amended from Representative Frederick. This expands the professionals who may conduct a substance use disorder comprehensive assessment. Section 22, also from House File 1993, modifies treatment coordination provider qualifications. Sections 23, 24, and 26 are from House File 2143 as amended. These all add tardive dyskinesia to medication-related sections in Chapter 245I. Section 25 is from House File 98. This modifies direct observation progress note requirements for mental health behavioral aides and mental health rehabilitation workers. Section 27, also from House File 98. This adds client grievance rights in Chapter 245I, the Mental Health Uniform Service Standards chapter. Section 28 from House File 1963. And also there is some new language, and both are from Representative Frederick. This section does two things. First, it requires eligible vendor recovery community organizations to comply with the transfer of records procedures in Chapter 245A when a program closes. And the section also requires recovery community organizations to be certified by MARCO, the Minnesota Alliance of Recovery Community Organizations, to be eligible vendors of peer recovery support services. Section 29 from House File 1963. This excludes weekends and holidays from the Mental Health Diagnostic Assessment 10-day timeline. Sections 30 to 32 are from House File 671. These are peer support and family peer support clarifying changes, and they relate to initial training and continuing education. Sections 33 and 34 from House File 98. These modify assertive community treatment or ACT team supervision and team leader requirements. Section 36 from House File 1963 specifies the county of financial responsibility for withdrawal management services. Section 37 from House File 973 from Representative Backer specifies that co-payments, co-insurance, and deductibles do not apply to mobile crisis intervention or crisis assessment services. And Section 38 is from House File 1995, the first engrossment. And this is just a revisor instruction to update comprehensive assessment terminology. And that concludes Article 4.
Thank you. And now we move to Article 5.
Mr. Chair and members, Article 5, which starts on page 156 of the DE, is the Department of Human Services Office of Inspector General article. This article contains sections from House File 2115, the DHS Policy Bill, and House File 2260, the first engrossment, which is one of the clones of the DHS Policy Bill that was amended along the way. So starting with sections 1 through 3, 28, 29, and 32, these are from House File 2260, the first engrossment, as amended from Representative Curran. This set of sections is the DHS illegal remuneration or anti-kickback proposals and the criminal penalty. Section 4 is from the DHS Policy Bill. This is an expansion of the Healthcare Bill of Rights to include patients in children's residential substance use disorder treatment, non-residential treatment, and IRTS or residential crisis stabilization and withdrawal management programs. Section 5 in the DHS Policy Bill requires training about a program's drug and alcohol policy before a person has direct contact with persons served by the program. Sections 6 and 8 from the DHS Policy Bill modify licensing provisions for adult foster care, family adult day services, child foster residence settings, and community residential services. Section 7 is from House File 1215 as amended from Representative Clardy. This requires DHS to provide technical assistance and legal assistance referrals to 245D license holders upon request. Section 9 from the DHS Policy Bill requires staff training on the use of opiate antagonists before having direct contact with persons served by the program. Section 10 from the DHS Policy Bill allows for electronic signatures for human services background studies. Section 11 also relates to human services background studies and is from the Policy Bill. It updates language in the list of entities from which the commissioner may review arrest and investigative information. Section 12 from the DHS Policy Bill adds financial management services, community first services and supports, unlicensed home and community-based organizations, and consumer-directed community supports organizations for purposes of background study limited set-asides. Section 13 from the Policy Bill specifies that community residential setting services are provided to adults. Section 14 from the DHS Policy Bill clarifies comprehensive substance use disorder treatment assessment requirements. Section 15 from the DHS Policy Bill reduces the time for an opioid treatment program to complete an individual treatment plan from 21 days to 14 days. Section 16 from the DHS Policy Bill modifies substance use disorder treatment guest speaker documentation requirements. Sections 17 and 27 are from the DHS Policy Bill. These allow a 10-week timeframe for non-residential opioid treatment programs, treatment plan review, and therapy services to include previous time in another similar treatment program. Section 18 from the DHS Policy Bill requires peer recovery support services to be provided one-on-one and face-to-face, including via the internet. Section 19 from the DHS Policy Bill requires SUD treatment program documentation, or SUD treatment programs to have a documentation system for schedules 2 to 5 drugs. Section 20 from the DHS Policy Bill modifies requirements for SUD treatment program client records. Section 21 from the DHS Policy Bill specifies services an individual with a temporary permit from the Board of Behavioral Health and Therapy may provide in SUD treatment programs. Section 22 from the DHS Policy Bill modifies training requirements for licensed alcohol and drug counselors providing treatment services to adolescents. Sections 23 and 24 from the DHS Policy Bill provides an exception to additional licensing requirements for substance use disorder treatment license holders to provide childcare for short time periods. Section 25 from the DHS policy bill requires an opioid treatment program to meet statutory and regulatory requirements for dispensing by a practitioner. Section 26 from the DHS policy bill for opioid treatment programs removes the requirement to submit a client's government-issued photo ID and driver's license number to the state central registry. Section 30 is from House File 1831 as amended from Representative Zalesnikar. This modifies background study requirements for housing support providers. Section 31 from the DHS policy bill adds the DHS Appeals Division judges and current employees to the definition of judicial official. Section 33 from House File 2260, the first engrossment. This amends 23 session law, an effective date related to changes to background study disqualifications for drug offenses. Section 34 from the DHS policy bill allows the commissioner to change definitions in statutes and rules for purposes of implementing the provider licensing and reporting hub for a specified time period. And Section 35 is just repealing outdated home and community-based services licensing standards and community residential setting license provider standards. And that concludes Article 5.
Thank you. And now we move to Article 6.
Mr. Chair and members, Article 6 is the assertive community treatment and intensive residential treatment services recodification. Sections 1 through 6, they're all from House File 2758 from Representative Fisher. And this article just recodifies Section 256B.0622 to separate ACT and ERTS into different sections. And Article 7 on page 193 is the article containing the conforming changes made necessary by the recodification in Article 6. Article 8, starting on page 201, is the Children's Mental Health Terminology article. This is 86 sections, and they're all from House File 2196 as amended from Representative Fisher. This is updating terminology by deleting the terms emotional disturbance and severe emotional disturbance and replacing them with mental illness and serious mental illness for children's mental health, and also deleting the term out-of-home placement where necessary and replacing it with residential treatment and therapeutic foster care. And it also makes conforming changes throughout statutes where appropriate. And finally, the miscellaneous article on page 286, Article 9. This is one section, and this is from House File 258, Representative Vernig. This is the requirement for the department to give notice to the revisers of federal approval of legislative enactments for the department. And that concludes the bill.
Thank you so much for the walkthrough. Chair Schumacher.
Thank you, Mr. Chair. I guess if there are any questions, we could take those. I would note that because this is entirely bills that we have heard, we were not taking public testimony today in oral form, but we do have written form packets in everyone's packets for today, and that if you read through them, it's not that anyone is way too happy or way too disappointed. So I think we made everyone equally frustrated with us.
Mr. Chair, I don't see any frustration in the policy bill. We'll wait for the finals. Member discussions. Representative Ganda.
I do have a question for staff. Thank you, Mr. Chair. Is there any chance that he put something sneaky in here that we want to pay attention to?
That goes to
Mr. Chair.
that goes to the chief author of the bill, Chair Schumacher.
Thank you, Mr.
not
Chair.
the staff. Any discussion? Representative Coran.
Thank you, Chair, and thank you, Chair Schumacher. I just want to say it's been a joy to be part of this process. I think I can speak for the committee to say, just under both of your leadership and guidance, I'm really happy with the final product that we were able to come up with as a collective team, and it's just really been a pleasure under both of your leadership. So thank you.
I hope that continues to next week.
You're hugging today.
Yes. Well, thank you so much for your closing remarks and moving the bill, Mr. Chair.
Yes, thank you, Mr. Chair, and thank you for allowing me to carry this bill. I would renew my motion that House File 2115 as amended be re-referred to the General Register.
All those in favor, please say aye.
Aye.
Opposed, say nay. The motion prevails, and the bill is on the way to General Register. So